As you know, the presentation is attorney well-being. You know, it's your life in the balance, right? You know, it's a kind of a rhetorical question, but that's what we're really talking about. Your life, not your profession or your income or your social status or you know, your job position per se. It's your life that we're talking about to balance out so that you can have that attorney well-being that we've been talking about, more so in the professional in the last couple of years. So this is a presentation that's being sponsored by the Criminal Justice Section. Our chair, Sandy Weinberg, is here present. Through his efforts, he helped us, encouraged us to put this panel together. And along with the Commission on Lawyer Assistance Program, we have the current chair, Bree Buchanan, that you'll hear from in a minute. So, you know, as I indicated, I'll be your moderator. I've been practicing law for a long time. I was a deputy federal public defender when I was very young and had black hair. I did that for a while. Then back then, because it was very, very poorly paid, I went into private practice for 20 years. And at that time, I was a pretty active alcoholic. You know, before I went to law school, I already had 2 DUIs and a third one in the making. Right? So, you know, if I was applying for the law for admission to the bar now, I'd have a real problem. Back then, you know, we had an interview with a representative of the other bar in California that kind of screened out individuals to see if he had an issue. I had the meeting. I said, of course I don't have an issue. You know, just, you know, got a little bit carried away a couple times. They gave me the blessing. I got my bar card. Of course, now it's a lot different. It might have been required now to go through a lab program before I got my admission, or conditional admission. So it's a lot different. But as a private practitioner with no oversight, for me it was a pretty bad combination, right? I had an obligation to my clients, of course, and to the courts. Other than that, it was free game, you know. So turned out I wasn't a very good businessman, but I was able to survive okay for 20 years, and went back to the federal public defender sober, and now I have a great job. I do a pretrial diversion program and a post-conviction drug court in federal court, so I'm not doing trials, trying to keep people out of prison and having them get the assistance that they need. So I'm working with my peeps and getting paid for it. Imagine that, on federal tax dollars. So I'm going to introduce our very distinguished panelists in alphabetical order. Bree Buchanan is a lawyer. She's the director of the Texas Lawyer Assistance Program. Currently, she's the chair of the ABA Commission on the Lawyer Assistance Programs that you'll hear more about for those of you who may not be familiar. She's also the co-chair of the National Task Force on Lawyer Well-Being, which put out a very, very thorough report that she'll go over. It talks about culture change within the profession at all strata. Derek Lacroix is a I don't want to say a retired practicing lawyer, but a previously practicing lawyer. And he did criminal defense and business and other things. He did some counseling. He's been the director of the Lawyer Assistance Program of British Columbia here in Canada for the last 20 years plus. He's also been active with the Commission on Lawyer Assistance Program on the commission, on the advisory commission, and also on the committee that helped puts together the national conference that the Commission puts on every year for directors of lawyer assistance programs, for lawyers, and for treatment providers to get together on a yearly basis to talk about these issues. Tracy Kepler, currently the director of the ABA Center for Professional Responsibility. She does way too many things, so I had to write them down. You'll be able to see their bios after all the materials are posted on the Criminal Justice Section website. But Tracy's been pretty active. Everybody has, you know, including Tracy. But currently, she is the director of the Center for Professional Responsibility, which oversees about 13 different entities, including 5 standing commissions of the American Bar Association, including ethics, professionalism, professional regulation, client protection, specialization. She's worked with the Patent and Trademark Office, the Illinois Attorney Regulation and Discipline Committee. She's been an adjunct professor, so if you're even thinking of getting into trouble, come and talk to Tracy first. The first 15-minute consultation, I guarantee you, is free. After that, you're on your own. And then last but not least, of course, we have Amanda Richards, who's the 1L over at the Peter Allard School of Law here in the University of British Columbia. I want to thank her in particular. It takes a lot of courage and guts to get up here as an entering law student who's looking at the profession to talk about these issues, and she'll talk about some of her own personal experiences. So I think we have a very well-rounded presentation. Anywhere along the lines, if you have a question, please feel free to ask. I'm going to give a brief platform, if you will, to tee it off to our speakers. But as you know, our legal profession is guided by ethics, right? We are a profession by definition, right? We have a job that requires special education, training, and skill, and clients are our focus, right? It's always the client is the number one, and as well it should be. We are that kind of a profession, and we're guided by certain codes, right, of ethics, both state and national. The ABA, of course, has a series of canons and model rules of professional responsibility that guide us in terms of what we should do. And of course, us in the defense bar, and of course, even the civil litigators, we'll talk about lawyers as advisors, zealous advocates, right? So sometimes, we take that to the limit, right? And we put our all into that in terms of representing a particular client or case, oftentimes to our detriment. As you know, state bars also have their rules. I'm not going to go into any particular details, but this is just an example. The bottom line is kind of the key for me. If we fail to abide by rules of professional conduct or responsibility, we're obviously subjected to discipline. And discipline can be a public reproval, as you know, or a private reproval, or actual discipline, or disbarment, suspension, disbarment. So there's a lot riding at it on our actions, because, as I don't have to tell you, especially the younger ones, what it costs to get into law school, the competition, the debt that you have to pay, the scramble for jobs. We put a lot of investment into our bar card, so to speak, that can be taken away in an instant by our actions. So our legal profession, our roots in the legal profession for lawyers, of course, in the past, not so much in the current situation, but it's been a slow change. But if you look back, 60 years ago, it was pretty much an Anglo-male-dominated profession, right, with very traditional values. It was, considered an exclusive club, more so in the judiciary. Just look at who was on the bench and who were the leading lawyers across the country. We're guardians of our social, political, and economic system. To some extent, we still are now, but probably not in the same footing. We were respected members of an honorable profession, right? I don't think people 50, 60, 70 years ago questioned that. Everybody could earn an honest and perhaps even lucrative living, as a lawyer. And presumably, there's no studies back then, lawyers had high job satisfaction because we had a special role in society. Legal education, until most recently, was very static, right? Socratic method, and very little in terms of practicum. How to be a lawyer was something that we picked up either third year or summers, or if we happened to get a good clerkship, or if we happened to get an internship, then we had a good idea what to do. But pretty much, as you know, the law schools didn't really prepare us to be active members of the bar right out the gate. And the law practice has also changed, right? I think 50%, if you look at the statistics that are provided by the ABA, most of us or half of us are solo practitioners. Okay, that's the good news and the bad news. Right? On one hand, you get your own shingle, you can go out and make an honest living, but then you also have to be a businessman. You have to also handle a lot of different cases. You have overhead, all those kind of things that put more pressure and stress on us as human beings. Those of us in the public interest agencies, like the district attorneys, public defenders, county counsel, regulators, we have our own set of pressures. Just because we might be, for example, a public defender, doesn't mean that we're free from those kind of stresses. In fact, today I read an article about a lawyer in Seattle who was arrested for having meth. Right, so she was doing a misdemeanor calendar, and it's a very interesting article. I'll add it to the related materials or the reference materials. She'd been practicing as a public defender for the county. She'd done about 250 some odd clients. Hell broke loose. She got arrested for having meth. Even after got arrested, held on to her job a little bit, was rearrested again with more meth, skipped bail, and took off. Right? And so she had a long-standing problem with her addiction that went unattended. And that's kind of part of what we're going to talk about here. Left to our devices and left unattended, we're going to run into problems. District attorneys too, they also have their set of pressures, not only in terms of working with law enforcement, but then there's also secondary trauma. There's a lot of blood and guts sometimes for the local prosecutors. For defense counsel, one of the citations is we can also often suffer from secondary traumatic stress, burnout, those kind of things from a large caseload and from compassion fatigue and those kind of things. In the traditional law firms, of course, there's in the past more so you had your firms with named partners and a number of associates and other equity partners. Back then, if memory serves me well, they were relatively smaller in size, of course, and more limited in number. It didn't have one on every corner that had a big name that was looking for the similar type of clients that everybody was looking for in terms of a big corporate practice. Back then, perhaps limited competition, and of course, lack of diversity. Male, female, ethnicity, those kind of things. It was pretty homogenous back in that day. Big laws, came along and became national and international conglomerates, right? 1,000+ lawyers. We had several of those across the country and across the world, right? They come with their own set of issues. So that's kind of the backdrop, if you will. And the challenge is, what we want to stress here, of course, is unchecked stress will kill us. And Derek and Tracy and Bree and Amanda will give more details about that. But, lawyers, when we come in, our motivation for becoming lawyers sometimes are very clear. I wanted to be a lawyer since I was in grammar school or high school. Or I want to be able to address immigration issues or criminal law issues. We come in very specific about what we want to do. Others come in undecided, particularly in the last wave, right? We already have a lot of lawyers. People go to grad school or thinking about going to grad school. Well, I don't know what I'm going to do, and they go to law school, right? Invest another, several $100,000s to become a lawyer when they're undecided about that's what they really want to do, right? So the numbers of the profession have gone up dramatically over the years. And the reality of practice, of course, is much different, right? So, I go to law school, I got a $250,000 debt. If I go to the public defenders, I may get, $50,000 a year. It's going to take me the rest of my life to pay it off. That's what I really want to do, but I need to pay off the debt. I want to have a family, buy a house, those kind of things. I'll go to a law firm and do stuff that I really don't want to do, right? And, people do that, and some of them love it, some of them don't, and that creates a tension within what some of us call our authentic self, right? So we create that tension of who we really are and why we're in the profession to begin with. And then, of course, that can develop into physical and mental health issues. Right? Substance use rates are double that you'll hear about in a minute. Depression and suicide are real issues for us lawyers. And, of course, relationships and family issues are up there in terms of the issues that we face. Law practice, the same thing. What's the motivation for practice? Of course you want to do high-quality, specialized legal services for profit. Right? There's nothing wrong with that. You got to survive, and you're going to have mouths to feed both within the firm and outside the firm, right? So the traditional practice, you leverage your associates. You bill them out at X amount of dollars. You put a markup on that, and that money gets distributed with, of course, the equity and non-equity partners, right? There's a competition for that. You'll hear a little bit more in terms of some of the resistance to change. There's lack of innovation at the core of that kind of equitable structure within firms, right? The equity partners want to keep the equity. The non-equity partners want to get some of that pie. The associates want to become equity partners. And so there's a lot of internal conflict over that. And there's little tolerance for failure, right? So if you're, I'm not only just talking about mishandling a case or a client, but if you show signs of other issues, mental health issues or substance use issues, it's easier to target you. And then for people of color or minorities or diversity, it's sometimes, it's like a double whammy, right? You come into the firm, and I'm not saying that this is the way it is everywhere or that there's malintent everywhere, but you're the last one, you're the last kid to show up on the block, right? And if you have some of these issues, you're the last one that's going to want to admit them, right? And one of the recurring themes you're going to hear is the lack of being able to come forward to deal with these issues. Because if you do, then you're kind of laying it out there, and we'll talk about that in a second. And of course, post the 2008 financial crisis, which had somewhat of an implosion, reduced fees, firm size, even for public funding crisis, right? You've heard of the state of Louisiana, what's going on with their public defender system. So it's a real issue in terms within our profession. I'm going to skip over this. We all know the hallmarks of our criminal justice system. Just look at the bottom line. It's really trial by combat, right? And sometimes it's take no prisoners, winner take all. The whole issue about collaborative courts is, and the state courts have been around for 25, 30 years. The federal system, maybe, 10 at the most, mostly in the last 5 to 7 years. It's a hard nut to crack, so to speak, to be able to look at alternatives to just, making grist out of our forensic or, defense, criminal defendant population. And so, I'll end my introduction here. So, we have our United States Constitution, right? We went to law school thinking, well, yes, we have these guarantees, a fair and impartial jury of our peers, right? It's going to be free from bias and prejudice, right? All are equally afforded due process of law. That's the Constitution, for crying out loud. But the reality is different, right? And this is just one old example, right, that we see even more so today, right? People getting beat up, and who's being held accountable? Almost nobody, right, from that side of the fence. So that's my soapbox introduction. I'm going to tee it up now for Derek to take us on to what are some of the more obvious effects that stress, unchecked stress, has on our mind, body, and soul. Derek?
Great. Thanks, Ron.
Of course. Let me get you right there. Forward and back. Does that have a pointer?
I got one. Okay. I got one. Anyway, hi. Great to be here. I still think of myself as a criminal lawyer. I don't practice it anymore. I'm still licensed to practice, and I'm a non-practicing lawyer in Oregon. And I wanted to be a criminal defense lawyer from the time I was 9. We had a prime minister named John Diefenbaker, who was a legendary criminal defense lawyer. And he mentioned something, and I see my colleague here, Don Sorokin. Back when we were young lawyers, I think my mentors, and I suspect yours, told us, go into court and fight like tigers, and then come out and be colleagues. There was a real collegiality 45 years ago, 40-something years ago. And it's part of, that fits in with this, what's that?
iPhone.
Nope, sorry.
Excuse me.
Okay.
Thank you.
It fits in with the balance, because if you're always on, if you're always fighting, it's going to affect your brain. And I'm going to talk a little bit about the brain and a little bit about just the stresses, and mostly in the way that they apply to lawyers. And I'm so excited. One of the best things that's happened and renewed my enthusiasm, not that I really needed it renewed, but is this creating a movement to change the culture of the legal profession, to make it health and develop on well-being. And well-being just means the whole person. And one of the things I do want to say, because so many people say, oh yeah, but we have to work hard. Yeah, work hard. That's part of well-being. I love working. That's not the problem. The problem is we forget these other parts. We forget to go to battle and then come out and de-stress. We forget about our families. We forget about spirituality, and I'm going to talk more about that because I was so thrilled when the task force mentioned the word spirituality, because it's not mentioned enough among lawyers. It has to do with meaning and purpose. That's all. Like, it has to do with more too, but meaning and purpose. And when we look, you see, we got here the brain, and it's all one. It's a big one, but there's, let's call it 3 parts. There's this part down here, which is often called the reptilian brain. That's the first brain. And it's fight or flight. We go to combat. There's a lot of fighting goes on as lawyers. There's fight or flight, adrenaline, and it regulates the neurotransmitters. Then there's this area. That's the reward, the pleasure center. I feel good. Yeah, this is nice. Why would you do anything? We want to feel good. And then there's this, and this is the last part of our brain developed as humans. This is the part where we think, we reason. This is the lawyer brain. This is where you're worth your money. You're not worth any money down here, really. This is reflex and stuff. But this is what you want to keep fit. But that won't stay fit if this isn't fit and this isn't fit. And here's what happens. So until you learn to self-regulate, until you learn to not be too fixated in stuff, and learn how to use your brain, all three parts together, because this part, what you think and how, including what your beliefs are, what your values and meaning are, will affect your sense of pleasure, and it will affect the fight or flight area. And what happens, though, with lawyers, and I'm going to say something. As lap directors, we've known about problems in the legal profession for years and years and years and years. And we debate among ourselves what the cause, and there's a whole bunch of different causes. This is one of them. And this is at a physiological level. And that is, we get into a stress situation. And somebody phones. You're all criminal lawyers. I got to go to court. I've got to do this filing. Or you meet a client, and it's stressful. And this part can get, actually the amygdala is the little regulator that regulates the neurotransmitters and the amount of transmission up into this part of your brain. What happens if you stay on alert too long? The amygdala wears out and gets dysfunctional. Then what happens is when a stressor comes in, it isn't mediated by this. It floods this part of the brain, and this shuts down essentially. So back to the old days, this is a very old system. You've probably all heard this. Saber-toothed tiger comes in, this lights up, you run away. Or enemy comes, you fight. This is I like to say that because I also am in recovery, and I had horrible anxiety problems, and a lot of it had to do with this. And by the way, if any of you played sports, particularly football or basketball, having a very active area here is really good because you can avoid things and hit things. But in those sports, you also blow off the steam and you moderate this, and you moderate the cortisol and all the hormones going through. Not so much as a lawyer. You just wear them, and they stay in there. Then the reward center is kind of numbed out. And so what happens is we need more and more to get any pleasure. And I was always like this all my life, but work will make this go squirt. You'll get dopamine and serotonin, and this can feel really good, work. How many of you go to work sometimes? It's really going. I know, trials. How much fun is it, particularly a jury trial? It's like a high. It's great. Or a great interview with a witness or something. You come out going, hi, it's great. Then most of us is going to the next one and the next one. And pretty soon, this gets kind of numbed out, and the receptor chemical balance goes off, and you need more. And then you add alcohol. Or I didn't so much suffer from depression as I did from anxiety, because I was always going for more and more, and then I was always activating this part. But this will get all numbed out. The serotonin gets out of balance. You can't appreciate dopamine, and pretty soon you just feel like crap. That's a clinical word for not feeling very good. And when both of these happen, when this gets flooded or you get too preoccupied in here, this shuts down. Now, this is where you're earning your money. So now if you're at work and these are really not functioning well, this isn't functioning well. Even if you think it is, you're at half-mast. Here's where it gets really bad. Now, this isn't functioning so well, so we try harder and stop thinking about what's important to me. Stop thinking about making real good planning and judgment. We're just using this as crisis management, which then this activates this and numbs this. So now you got a system that's a loop, and you're really in trouble. And how does that sound like your life? Can any of you identify with that? Like I know you guys must, because you're there all the time, always confronted. Unless you learn techniques to. No. Brighter.
See, it lit up.
That's right. I'm not actually much of a power. This is like, I don't do PowerPoint much, so I'm having fun. I don't know. This is lit up for me. I'm feeling good. Hopefully I can keep this going, though. Then you guys can feel good, like you're getting something. Does that make sense, where you just, how many of you do a trial and then the next day do another one, or do a week-long trial or a 2-week trial, and then the next week you do another one? It's not as common as it used to be, maybe, but sure, I run into a lot of my clients who are doing litigation, and when I talk to them about their schedules, it's just like they've just finished a 6-week trial, then they're starting another one with no vacation, no time off, no acknowledgement. All the while, if you're doing, because you guys are criminal lawyers, so you do trials, it's not just you do the trials, then you come back and you have all your paperwork, you have your research, you have all that. That also stresses you out. Well,
The green one, this way.
well, there you go. That also stresses you out. So you're living in a culture that's just not really made for this. It's just not made for it. It's a high stress, I like that, trial by combat. You're in fight. Unless you learn how to regulate yourself, you're going to be in trouble. One of the things that struck me is, in recovery, I've been working on myself, like I'm my own guinea pig for like 30 years. I didn't start out to be a counselor. I just wanted to get back to doing jury trials. And I was in my 2nd year of recovery. Well, I was in my 3rd year of recovery. I'd finished 2. I really doing a lot of stuff. I was back doing big trials. And one day I'm sitting in my office doing some very complicated argument, putting it together. And it's going to sound weird, but I had a felt sense that my brain was operating easier. I don't know if anybody's had that. It was a very weird, it wasn't that I was having better thoughts. I'd already got back that cognitive ability, but I was putting more effort in. It was that, my brain is just working smoother. And we lose track of it. I had lost track. I didn't really realize how hard I had to work to make this go. Just way more effort than I needed to, because these were out of whack. Once these were in whack, this was smoother. It was not that my thoughts were better, it's that I was using less energy. And that's what I call well-being and sustain. It's sustainable. Do you have a sustainable life? And you can work as hard as you want. You can put your energies how you want, but is it sustainable? And it ought to be somewhat smooth. And I think lawyers get used to suffering. I've got to figure out if I can do this. Now, just in the relaxation and in stress, this is a standard form. Here's a healthy stress response. This is what happens. It comes in, there's the stressor, stress response, you go back, do the relaxation response, back here, and you float up to here, and you're back to homeostasis, it's called, and away you go. Then another stressor, and you're up and you're down. And that's the old, come along, saber-toothed tiger, run, relax, or fight, or do something, burn off the steam, get back, go. That's not, here's more how it works for lawyers, and it's pretty unhealthy. This is the unhealthy one. This is the one, homeostasis, stressor. You're up, you just get down, boom, there's a phone call, boom, then you've got to be in court, then there's there. And you just keep going, and then it's day after, you might even take a weekend off, get down to here, back up. Does that seem familiar? It's just one thing after the next. And here's the magic to this, I will tell you. Well, here, I'll go on to the next slide, because this is a classic old slide. a guy named Hans Selye, a Canadian, sort of came up with the adaptation, and that is that we go along homeostasis, then there's this fight or flight, and then we're back down here, back to homeostasis. What happens is if you don't come down here for long enough, your system, you don't even need an external system, stimulus. Your internal system, this is back to the brain thing, will automatically just be an internal stressor. So now you're stressing yourself just sitting there. Your system is, and that's what's called chronic stress. We just lead to chronic stress. And some major kind of intervention need to do something significant to stop that. Here's the excellent news. And that is this piece down here, below homeostasis, to back up, does not have to equal the amount of time you're stressed. All you have to do is periodically get your system down below the homeostasis line and back up. So you can do this with periodically during the day, taking a moment to breathe or just to unlax. Or one of the things I used to always do in trials when I was doing jury trials is take a break on the break and go out by myself, usually either into a little ante room or somewhere, breathe, just shake, de-stress. Talking to other people is really, like not bitching and complaining to other people. Just talking to other people, getting engaged with people you care about. Prayer and meditation. Meditation's like magic, by the way, on the brain. That frontal part of the brain, meditation and prayer will light that up and help you develop it. They're also very relaxing. So you don't need, it's not like you need to have, okay, I'm working 8 hours a day, now I've got, or whatever, 60 hours a week, now I've got to do yoga for 60 hours a week. It's not like that. It's like you just need to periodically, consciously bring yourself down. Now, here's another thing, and I'm going to kind of shift into some more external stuff, and this relates partly to stigma, partly to, well, the whole reason why one of the things lawyers don't get help. And see that? Oh, there you go. There's an alcoholic, right? You guys all recognize an alcoholic? This old-time drunk? That's actually not what a lawyer drunk looks like, by the way. If you think you have a problem with alcohol or you think somebody else does, that's not what they're going to look like. And one of the reasons I bring this up is I can't tell you how many people I've had come into my office and say, I can't be an alcoholic. I'm not drinking out of a paper bag. What did I do? By the way, I went ahead on its own. That is what an alcoholic lawyer looks like.
That's right.
Right there.
Right.
And statistically, probably if these are lawyers, 1 in 5, one of these is an alcoholic. Tell me which one. One of them. Whoa, stop it. Get back. Get back there. Not only that, so there's stigma. The stigma is we think we have to look like this to be an alcoholic. We think an alcoholic is that kind of broken down person. Alcohol. That's part of the stigma, is that we think that's beautiful. We think, yeah, that's very cool. Cool and beautiful people drink wine. Back in the, 40 years ago, cool and beautiful smart lawyers drank scotch. We've evolved. Come to wine drinkers. We think that's a mental health issue. That's what it looks like to be depressed or anxious or a mental health person. That'll stop a person from admitting they have a problem. That'll stop a person. They'll say, whoa, boy, that person doesn't have a problem. Look, that's the problem. But that's not it. Here you go. 1 in 3 lawyers probably depressed or anxious or something. If these are 3 lawyers, one of these people is depressed or anxious, and that's what they look like. Whoops. Just like any of them. That's exactly what you're looking for. So if you're looking for yourself, especially in lawyers, don't be looking at the external. And also when you're meeting somebody or you're thinking about yourself, don't think that if just because you have an anxiety problem or some mental health issue, you're that person. That's not the case. It's just that the frontal part of your brain isn't really, your whole brain isn't really operating at 100% or even 90%, probably even 50%.
2 minutes, 3 minutes.
Okay. Now here's the standard. What I do want to say, in yourself and in other people, don't try to diagnose yourself. All you have to really look for, now this says addictive behavior, but it's mental health behaviors too. Look for particularly notice and changes in attendance, performance, behavior, personal habits. It's very simple. For yourself, for somebody else. Are you starting to get late? Do you miss things? Do you, I would even say, and performance, is your performance erratic maybe? Might even still be pretty good, but is it erratic? Has it changed? Does it change from day to day? Has it changed? Are you down? Personal habits. Do people look neat and tidy? Or do they look less neat and tidy? Are they erratic? Do they blow up at people? How's your relationships with people? Look at those things. Like people with mood disorders or addictions, all of a sudden they start to isolate. Their relationships are different. They might be irritable. You could look for any of those things. And they could be very subtle. You don't have to look, anything in those categories, you just start to look at it. How come Raul, who used to just always show up in court, he'd be just right there, ready to go, 10 o'clock, boom. Ready, Your Honor, my lord. Now he staggers in or just walks in just casually. He may or may not smell of alcohol, may not be that. He may even kind of know what he's doing, but it's just a little different. Or how about even yourself? You kind of go, if you're somebody who really cared about how you look and your clothes, you kind of go, I don't really care. You're no longer taking particular attention to things you used to. So those are early warning. They can be early warning signs. And what we say from LAPS is call early and call often. And this gets back to the task force and why we need the change so badly. What it shows, there's all the bad statistics, blah, blah, blah. What shocked me was how resistant lawyers are to getting help. And that's the message. Get help early on. Get help to keep your brain, rather than to try to fix your brain once it's way off, to keep it sharp. I would say, Stephen Covey talks about sharpening the saw. I have a coach. Anytime I'm making a significant change, either in my life or in the LAP or some other business, I have a coach. Get a coach or talk to the LAP or talk to somebody if you start having some concerns about any of those, just some concerns. And then they may be able to help you and keep you from really tensing up. So thanks.
Thank you. Thank you, Derek. So as I call up Bree to come up, I just want to see a few things that I failed to mention. Bree is recently been a presidential appointee to a working group to advance well-being within the legal profession, appointed by our president, Hillary Bass. Was formerly an adjunct clinical professor at University of Texas, dealing with issues of family violence and children's rights, and is currently a grad student in the Seminary of the Southwest, seeking her master's in spiritual direction. So, Bree,
right.
Please.
Thank you. Good morning, everybody, and thank you for the opportunity to be here and to address you. And I'm going to speed through a presentation that I usually do in an hour to an hour and a half in 20 minutes. So we've already covered a lot of things, but there are things that are going on nationally that you guys really need to know about, and I hope that you can be a part of this. So I am the co-chair of the National Task Force on Lawyer Wellbeing, which formed about a year and a half ago. And you can see here the different organizations that have come together as of this date to be a part of this. For your knowledge, there is a website now that we just launched that a couple of weeks ago. You can see a copy of the report. It is lawyerwellbeing.net. But you have a variety of national organizations and ABA entities who have come on board to look at this. And this, backing up a little bit, this effort is really born out of a couple of studies that were done around looking at the rates of substance use disorders, mental health disorders, and the abysmal rate of help-seeking behavior by both law students and lawyers. And these are the two studies. They were both published in 2016. Those of us who do this work, we didn't have any of these statistics or hard data. We only had anecdotal information. that these were problems. And now we have it. Now we have been able to substantiate that these things that we knew and we saw in our practices are real. And so in 2016, the heads of these three organizations, the National Organization of Bar Council, the Commission on Lawyers Assistance Program, and the Association of Professional Responsibility Lawyers, came together and we said, we've got to do something. So at the ABA annual meeting in San Francisco in 2016, those groups and a couple of others sat down and decided we were going to take this on. So let me talk to you real quickly about those two studies, just so you're operating with the same information. This was the Suffering in Silence, which is I think a really great title for what's going on with law students. So the study looked at law students. It was very representative, 15 law schools across the country, 3,300 law students, and found that at the time of that this was done, 1/4 of them were testing out at basically what would be considered being at risk for alcoholism. Mental health, 17% experiencing issues of depression, high rates of anxiety, a disturbing rate of suicidal thoughts just in the last year. And also among the law students, they found that there was a very low rate of help seeking. Students that were experiencing some of these issues were truly afraid to ask for help, to seek help, because they thought that it would affect their ability to get a job or be admitted to the bar. Incorrectly on some of those, but a lot of fear, a lot of misperception. And one of the things the studies showed also is that with each year that their law school career advanced, the fear to ask for help, the rate of help-seeking behavior actually decreased. So there's a message going on from the law school and their fellow students, and I would say from the profession, that it's not okay to be vulnerable, to experience some of these issues and come forward and ask for help. Such that half of them said it's just simply better to hide this. The other study that was done nationally, 13,000 lawyers, was published in 2016. And here, this was a study put together by the ABA Commission on Lawyers Assistance Programs and the Hazelden Betty Ford Treatment Center. And one of the things they looked at is the rate of problematic drinking among lawyers. And problematic drinking was defined as possibly hazardous and even physically dependent. So it's pretty severe stuff. So 6.4% of the U.S. population over the age of 25, all attorneys, 21%, who responded to this study. There was a large number. And then if you look at the lawyers who are under 30 years of age, 1 in 3 were testing out as having rates of problematic drinking. Now think back of the problems that we're seeing in the law students. Now we're looking in particular at that group of lawyers who are in their first few years of practice. Lawyers, we had 17% rate of depression among law students. We'll look at what the study showed for lawyers. 28% tested out as experiencing symptomology of depression across the board. And I think that what we have the most thing to worry about of our profession is that this study showed that very demonstrably that the younger the lawyer, the greater the rate of impairment of whatever kind, depression, anxiety, substance use disorder. And that has really turned on its head what we used to think. We used to think that the longer the lawyer did this, the higher the rate of the depression, the higher the rate of alcoholism. And what we're actually seeing, whether or not this is a change or it's always been this way, but what we now are seeing is it's the younger the lawyer, the greater the problem. And also the barriers that lawyers had to seeking help or engaging in help-seeking behavior was just the same as with law students. It's not getting better. It is about the stigma and the shame that still covers these disorders, these diseases. And it's really, the message is out there for lawyers that it is not okay to ask for help. So at this meeting, these organizations came together and we have decided we have to do something. And we formed in that day, a year and a half ago, the National Task Force on Lawyer Wellbeing, with really the no small objective of creating a movement towards improving the health and well-being of the legal profession, which sounds like kind of crazy. It sounds kind of crazy now. When we did this and we wrote the Path to Lawyer Wellbeing, Practical Recommendations for Positive Change, a report of that task force, We wrote that on nights and weekends, very much disregarding our own well-being. We often commented on the irony of that. Getting up at presentations and everybody in the task force is sick. Yeah, because we've worked so hard on this, but we all feel very passionately that the time is now that we have to take action. And so this report focused on, we decided to sort of swing for the fences. We're not going to just talk about how do we address the impairment of lawyers. We also have to talk to the entire profession about how do we thrive? How do we attend to our well-being as an issue of prevention such that we don't fall into one of these areas of impairment. So the report is focused on both the well-being and impairment. It's 44 recommendations directed at no small task of changing the culture of the legal profession. And we decided that this is not going to be a report that's telling individual lawyers you need to eat your vegetables and exercise, because you guys know that. This is telling the chiefs justices of each state Supreme Court, the head of the managing partners of big law and the major law firms. This is going to the deans of the law schools, et cetera, the directors, executive directors of the bar associations, that you are the leaders of the profession and it falls upon you to make a change and lead us in that direction. And so that's what we decided to do. And we've already mentioned, Derek said, what is the Brown well-being? And one of the first things we had to do, because there was no definition of what does it mean for a lawyer to be well? And what does that look like? And so we had to be able to imagine that from the start. And I understand that it's difficult to read this, so I'll say that we looked at the model for well-being, something where we are attending to all sectors of our life. So it's looking at well-being in the area of our occupational, intellectual, spiritual, physical, social, and emotional health. This was derived from the definition put together by the World Health Organization, by the way. And so we knew that we were going to have to move the leaders. We needed to give them reasons. Why should they do this, and why should they do it now? Those of us who were sitting at the table that day, we felt the answer was clear. Well, lawyers are suffering. We've got to do something. It's incumbent upon us as fellow human beings and members of a profession that is charged with self-regulation that we need to step up and do something. So we were moving forward out of the humanitarian reasons, but we also knew that if we're going to shift the profession, we had to speak to what makes a difference, and that is business, quite frankly. And that it is about organizational effectiveness. If you have a healthy workforce, you are going to have a healthier firm, a healthier profession, a healthier bottom line, quite frankly. And also it's about the ethics of our ability to attend to the justice system, to best represent our clients. Well-being is directly related to our competence to practice law, our diligence as lawyers. So what this boiled down to is coming up with a series of recommendations that attended to these 5 areas, really identifying the stakeholders and their roles, putting it on their shoulders to move forward with this. Essential to all of this is addressing stigma associated to getting help. If we can't move the bar on addressing stigma, we're not going to be able to do anything. We have to make it okay to talk about substance abuse, depression, mental health issues, suicide that's occurring in the profession. So kudos to the criminal justice section for hosting this. This is new for us at the ABA to be having major sections of the entity to sit down and have presentations on this so we can talk about it. That in and of itself is a shift. We have to talk about that our basic duty of competence also starts with basic well-being. We must educate all sectors of the profession on these issues so they can identify it and know how to handle it, which is basically what we're saying is you don't need to diagnose, you don't need to cure, you don't need to treat, but you do need to know how and when to refer lawyers, judges, and law students to your lawyer's assistance program, and basically making all of these things a priority throughout the profession. So I have a lot of the slides, and I don't want to take up a lot of time with this because I encourage all of you to go and read the task force report if this is something that is of interest to you. So I'm just going to pick out a few of the slides. We divided it into general recommendations and then specific recommendations to the different stakeholders. And one of the things that we're looking at right now in the legal profession is where we are, this National Task Force was passing it off. We're passing the ball to the chief justices of each of the state Supreme Courts. We actually, my co-chair and I, Jim Coyle from Colorado, and I had the honor and the privilege to address the Conference of Chief Justices this past weekend in Henderson, Nevada, to talk to them about what we're asking them to do. And you want to talk about audacious and downright cheeky. We're standing up there trying to tell these chief justices what they need to do. I will tell you, when we wrote this report, we didn't know that anybody would even read it. And as we were there up on a dais like this and we asked the chiefs, who here has read it, every one of them raised their hands. That is amazing to me. And many of them are ready to start forming commissions, task forces, et cetera, on how they're going to start addressing well-being in their individual states. So we really are passing this on to the states to develop a state action plan, and also, for example, Hillary Bass's working group to advance lawyer well-being is also a piece of just instituting a national conversation on these issues and developing a national action plan for our profession. There's the issue with stigma. And then we're also encouraging everyone to know about lawyers' assistance programs. And I'm going to end with this. I see some questions, some hands being raised, and I'm kind of being greedy with the microphone because I know that we've got so much to cover. And I want to make sure that Amanda gets the opportunity to speak and say what it is that she feels it's important for you to hear. But as I'll wear my hat now as chair of the Commission on Lawyers Assistance Programs, for everybody needs to know in this audience who are watching this video that there is a Lawyers Assistance Program for every state. We have been sort of carrying the ball on attending to lawyers' impairment and lawyers' well-being for years, and now this is opening up. We're starting to have lots of partners at the table, but we need to know that in your state is where the expertise really resides. If you decide going back to your jurisdiction that you'd like your local bar to talk about some of this, to have a presentation on this, if you know of someone in your office, in your community, a colleague who may be suffering from one of these and you don't know what to do about it, call your Lawyers Assistance Program and ask them. And then we are all willing to accept calls that are anonymous. We are all confidential. We do not, cannot, will not share information with the disciplinary authorities in your states. So include us in the plan, individually and systemically, for how we can bring about a culture change for the legal profession. I'm going to pass the clicker on to the next person, and I may have a chance to come up and talk some more or not. Feel free to seek me out after the program.
Great. Thank you, Bree.
Thank you, Raul.
Thank you, Tracy.
Thank you for having me here this afternoon. What I really want to talk about is what we're seeing from a regulatory perspective, what we see in attorney discipline, and how all of these reports and these behaviors and these problems are affecting the attorneys that come before us. And what I start with up here right now is the most common violations that we see. And you can see that 61% of all the rule violations that come pretty much nationally, and this is a standard statistic across the country, come from poor attorney-client relations. And I say that because a lot of this relates to substance use disorders and mental health, but a lot of it deals with something that everybody has been saying, this failure to thrive, this malaise, this, and one of the words that they used in the report in one of the research study was the profound ambivalence to our careers and our profession that just makes us unable to reach out, to communicate, to do the work that we're supposed to file that brief, to do whatever it is. Other things that we're seeing, the fast track to disbarment here in three various categories. And the one that I point out here is the conviction of a crime. And this really goes to the heart and soul of some of the problems that we're seeing with regard to the alcohol use or the methamphetamine use or the opioid use, where attorneys are using prescriptions that often aren't theirs and that are actually violating criminal rules, criminal laws, to continue the use and to continue feeding that need. Why? Why do lawyers violate these rules? And you can see some of the reasons up there. Ignorance of the rules, okay, I'll give you that one. Busy, unorganized, and we tend to procrastinate. There are personal financial pressures, pressure to get and retain clients, pressure to win at every cost, and I think these are some of the things that Raul alluded to in his opening remarks. But the one I really want to focus on that's up there is the substance abuse as well as the mental health issues. When you look at the regulatory statistics, and we're going to look at some from Illinois, a lot of what we don't see, we don't know. Because oftentimes attorneys just fail to appear. They default in their disciplinary case. They don't come to a sworn statement, they don't come to a deposition, they don't even come to their trial or their hearing where their license is in jeopardy. And why do we think that's the case? Because of these underlying mental health or substance use concerns where people have such a stigma about even talking about it or addressing it that they'll just let their license go without doing anything. Cognitive impairment is another area where we're seeing problems in a lot of disciplinary cases because people are practicing longer, people aren't getting the help that they need, and that they're failing or losing clients or not attending to their clients' needs. Just a little bit about where these grievances come from. Oftentimes, and from angry clients. Clients are mad, they've lost their case, their attorney won't get back to them, it's grievances filed by them. But there are also other sources that we see from time to time. Members of the general public, newspaper articles, oftentimes we'll see self-reports where attorneys either have to do so because they have violated one of the rules or committed a crime. Reports from other attorneys. And this really fits into the topic that we're here to talk about today, where attorneys are calling regulators and saying, my colleague, I've seen him change. I've seen him not appear for court. I've seen him disheveled. I've seen him not returning phone calls. What can I do? What can you do? And that's oftentimes when the regulator will refer someone to a LAP program. No surprise for you in this audience where the areas of law where most grievances come from. Criminal law, high up there. Again, it goes to people being angry, and it also goes to people having a lot of time in jail or prison to file grievances with our offices. Domestic relations is another one. What we have seen, though, across the country with the disciplinary statistics is that when these problems go untreated, the lawyer's capacity to practice is almost always impacted. They violate one or more of the rules. They cannot continue to represent those clients to the best of their ability. And in addition, we've seen studies that show 40 to 60% of lawyers facing disciplinary charges suffer from some sort of mental illness or addiction. Just so you can see one state's statistics, and 2016 is the last year we have. Illinois hasn't published its annual report for last year. Over 5,400 investigations docketed. It was the fourth consecutive year or consecutive decline in grievances being filed. The typical age of the grievance, 48% of the grievances are attorneys with 30 more years in practice. It's a small percentage. Everybody seems to think, oh, look at all these big numbers. But it's really only 4.1% of the attorneys in Illinois, which is almost reaching 96, close to 100,000 lawyers in practice. 78% of those involved some form of fraudulent or dishonest practice. And I just like to throw this one in there because it's something hopeful and shows resilience and that attorneys really are doing good things. And you can see the number of hours that attorneys are contributing to pro bono legal services. If you want to see more about these statistics, the Illinois Attorney Registration and Disciplinary Commission, where I worked for 14 years, has a great annual report. And if you want to see some of these statistics nationally, on the ABA's webpage, on the Center for Professional Responsibility, there's a survey called SOLD, which is called Survey on Lawyer Discipline. And it gives you all of these kinds of statistics that we're talking about here today. Just some brief details on, so you know what an investigation entails. It's not like a complaint comes in and boom, we go to formal charges. We look at written responses, we look at a complaining witness's reply, we can take sworn statements, depositions, depending on the jurisdiction you're in. We also look at collateral sources. We interview witnesses, we talk to opposing counsel, we talk to judges, and we look at the respondent's working file in the matter, and particularly in conversion or misappropriation cases, we look at bank records. Some sanction statistics, again, from Illinois, and I think one of these is critically important for today's discussion. You can see the sanction orders that were entered. 54% of those were settled without a trial. 14% of those, though, were the defaults, the one I talked about where attorneys just don't appear. Again, 89% of those were sanctions against men, 68 of them between the years of 50 and 74. But this is the statistic that scares me the most, particularly in Illinois, and it's pretty standard across the country. 31% of those lawyers disciplined had an impairment issue. And as you can see what the statistic was the year before, 22%, it's a pretty big increase in a period of 1 year. And those are the ones that we know of because they have reported an issue or they've raised it in mitigation or we suspect an issue. 65% of the attorneys sanctioned were sole practitioners. Again, which leads us to a situation and a problem where the sole practitioners don't have anybody else to reach out to. They don't have anybody to talk to about these problems, and they're not contacting either their colleagues or the LAPs to get some assistance. Getting around this problem altogether, knowing the rules, knowing yourself. And it's something that Derek spoke to, about knowing when your brain is having the problems or going through that cycle that he described. Understanding yourself and knowing when to say no and when enough is enough and I might need to seek some help. Things to do when you make a mistake, I always throw them up there. Talking to someone, telling someone, addressing the issue head on, rather than hiding or lying to a disciplinary authority, panicking. Oftentimes we hear people being so anxious and so stressed out that the letter that they receive from the attorney regulation or disciplinary authority in their state, they don't even open it. They just let it sit on the counter because they're so afraid to open it. Hiding, again, lying to the client is always a bad one, and also lying to the regulatory authority will get you into trouble because it will be an additional disciplinary violation. Derek talked about some of the warning signs of an impaired lawyer, and some other ones are up here as well. And I share these with you so that you can be mindful of them and cognizant of them when you see them in your colleague, when you see them in your friend, or quite frankly, when you start to see them in yourself. We've talked about some of the attendance issues, the personal problems, that isolation, that pulling away from people who were friends or conversations, not being available, not going out to those dinners, not engaging in those social activities, and not finding the same kind of happiness that you once did is a big problem and a big warning sign. Financial issues, of course, performance problems, that's when it comes to our attention with the neglect, missing deadlines, blowing statute of limitations, and the health issues. And when I say in the red there about irritability, and or explosive, yes, we all can blow up every once in a while. We all have that moment where like, oh, enough. This is ongoing, perpetual, a change in behavior from something that's typical in that friend or colleague that you know. So what rules of professional conduct are we really looking at when we're talking about impaired lawyers? Bree mentioned some of them. 1.1, clearly, competence rules. directly tied to well-being. If you're not healthy and well, how are you going to be a competent lawyer to represent those clients? We also talk about 1.3, diligence, making the deadlines, and 1.4, communication with your client. Another one that I have up here that people often don't consider and often forget, and it does bring them into trouble before the disciplinary body, is Rule 1.16. And it's the withdrawal rule, or the termination of representation. It's not just when you have that argument or your client isn't paying you. It's when you have a problem, when your issue is impeding your ability to effectively represent that client. Your physical or mental condition materially impairs your ability. That's when you need to withdraw. Another rule we need to think about is Rule 8.3. In Illinois, that's called the Himmel Rule, and it's the rule where attorneys who know of conduct that involves fraud, dishonesty, deceit, or misrepresentation, or something related to a lawyer's fitness or ability to practice, you, as the person who knows that, outside of some confidential source, has a duty to report. When we look at regulatory agencies across the country, what do we do? How do we handle impairment issues when attorneys with these issues come before us? And really, you know, our mantra or our mission is twofold. We want to protect the integrity of the profession, and we also want to protect the attorney and protect the public and protect the public interest. So that's the first thing that we're looking for. But the second thing is to be more proactive. I think attorney regulators and disciplinary authorities have, in the past, been more reactive. A complaint comes in, now we prosecute, it's kind of a strict liability thing, and we just go forward and enter the sanction. Regulation is really trying to be more proactive in its approach, to get attorneys to deal with these issues and talk about them and get help before it actually leads to a complaint. And so that's really the second goal, to help the attorneys get back to this better self, to help them get the treatment that they need. So what have disciplinary authorities and regulators done to craft some options short of taking away your license, short of disbarment or exclusion? And there are a lot of them, because we certainly have learned that discipline or disciplinary sanction is not going to make a lawyer well. We had to come up and craft something else to help them get back to the practice, to help them get back to the better selves. And so many jurisdictions across the country have various options, disability suspension being one of them, where you can transfer out of the practice, either voluntarily or through a court-ordered evaluation, so that you can get the help that you need and then come back when the situation has changed. Many states across the country also have diversion programs. The newest that I've heard of is actually at my old organization, the U.S. Patent and Trademark Office, where they have set up a pilot diversion program, where people who have engaged in minor misconduct, maybe those kinds of neglect or failure to communicate, because of an ongoing substance use disorder or mental health issue, can be diverted out of the sanction and the complaint system and try to get them the help that they need without having to undergo the whole process. In addition, a lot of times when we're looking, because we know just a straight sanction isn't going to help someone, if they're going to impose a sanction or a period of suspension, they oftentimes tie that with conditions, where it may be continued treatment with a mental health provider, maybe an inpatient treatment session, maybe even anger management classes, things along those lines that can help the attorney get back to where they need to be to practice effectively and competently. Disability suspension, as I mentioned, incorporates all of the things that you see up there. We also have in many states a provision for obtaining medical records, and also provisions where we can compel psychiatric evaluations to get to the bottom of it, to find out what is really going on, and also to find out whether there's a causal connection between what the attorney is going through and the misconduct in which they engaged. As I mentioned, diversion programs, it's something where the conduct is minor. There hasn't been a substantial harm or prejudice to the client. They don't have a history of recent misconduct or past misconduct. And there has to be some indication that the participation in this diversionary program is going to be beneficial to the lawyer, to the client, to the system, and that it's going to further this whole goal and this whole mission that we have of protection of the public. When looking to when attorneys actually do come forward and they raise their issues about alcohol use or substance use or mental health concerns, we do take those into consideration as mitigating factors when looking at what the sanctions should be. Usually, those kinds of issues are really only a mitigating factor if the attorney has already sought treatment or is willing to seek treatment. And then again, we impose conditions that will actually help them get the treatment that they need, and that those conditions are effectively satisfied before they can come back to practice. And with that, I will turn it over to Raul.
Thank you. Thank you, Tracy. So I'm going to ask Amanda to say a few words from the law student perspective. Sorry, let me just get to this other slide for you. Thank you.
Hi, everyone. I don't have a PowerPoint, so I'm Amanda. I just started my first year of law at UBC. I am lucky enough to have substance abuse issues, mental health, and all those fun things before I attended law school. And so I was introduced to Derek, the director of the LAP program here, quite early on. And for me, I came to law school and I had a vision for myself. I knew who I was. There was a reason I was at law school. I was really happy with my life. I did well in undergrad and yada, yada, yada. So just as, you know, most people do when they come to law school. And I quickly found out that law school is a disaster. And people are depressed, they're anxious, their substance abuse issues become a problem quite early on. And there really isn't much help for us. I know that some of the statistics have been talked about with Bree, and there's really not a ton of statistics out there for law students, and especially not in Canada. This report actually came from the States, which I know most of you live there anyway. So, but yeah, it's kind of terrifying. Almost 40% had anxiety disorders, and I was actually speaking with a friend yesterday, and we make jokes about how depressed we all are and how anxious we all are, and it's kind of funny, but it's also really terrifying. You know, I'm constantly talking friends down. I just had a friend on the weekend want to relapse. I had a friend who was cutting herself. I've been talking to people who are so depressed that they want to die. There's so much pressure when we get to law school. And, you know, we all come fresh-faced, but nothing can prepare you for law school. It's kind of this whole new world where you come in and you don't know anybody, and a lot of us have moved to a new city, and you sit down in orientation and you're all excited and you don't really know what to expect, and they tell you, we're here for you, and here's all these resources that we have, and oh yeah, here's all these extracurriculars that we encourage you to do, but you don't have to do, but really you need to do them. If you want to get a job, and make sure you get good grades. Grades aren't important, but if you want to get a job, you need to have good grades. And so it's this this cycle of like, okay, well, I have to do this, and I have to do this, and I have to do this. And then it's like, okay, make sure you exercise, and you're eating healthy, and you get 8 hours of sleep, and don't forget about your family and your friends. And you're like, whoa, where's this time that you're like, am I going to like create this time all of a sudden? And so it's this new environment, and it's disastrous if you don't know who you are or if you're struggling. And because I had a lot of struggles when I was young, I'm like the queen of asking for help. I'm like, oh, I'm in pain, I need help. Like, who do I ask for help? And it's really great. But most of my friends, especially at law school, you know, they're type A personalities, and they come in and they're so depressed and they're so anxious, and you know, we talk to each other, and I try to pull it out of them, you know, like, what's going on? Like, maybe you need to see a counselor, maybe you need to seek help. And most people are so terrified to ask for help. And, so this whole problem with lawyers, it starts in law school. At least I believe it does. And I don't have the answers. I just started law school and I'm just trying to get through each day right now. But Derek has helped me a lot. Just being open, and I'm really open with my process and with my recovery and with my life, and I'm there for people. But it's not like that at law school. We're taught to keep our emotions inside. We had a talk a few weeks ago about how to interact with other lawyers, and they said, don't ask them about their personal lives, just ask them about work. And so for me, I don't live by that. I want to know about you. I want to know how you're doing things, and I'm really interested in your work as well. But it's like this dehumanizing. There's no human in the law profession now, and it's really quite terrifying. And so for me, and my goal is to just get these talks going at law school, and to be open and to be honest with people. And if you're struggling, I think that's okay. I think we all struggle in our lives, and Derek's been a really big supporter for that. And I promised myself when I came to law school that I wouldn't lose my vision about why I'm here. I don't really know why I'm here. I just know that I don't want to lose myself in the process. And so sometimes I find myself going there, but Derek always brings me back. And so I think that the LAP program can be really important for not only law students, but for lawyers as well. And again, I don't know anything. These are just my experiences and how it's helped me, and how much struggles I see in law school on a daily basis. Sometimes I have to come home and call like my mom or someone not in law school and be like, everyone's so depressed. What do I do? How do I take this on? And so it's really hard. And I think that it's the people up here that need to start looking down, at us, and start being, well, what can we do for them? And there really isn't a ton of resources for law students, and they say there is, but they either cost money or they're too afraid to ask for help. And so I feel that my job is just to say that it's okay to struggle and it's okay to ask for help. And I think that the profession as a whole needs to start opening that up and letting people, just speak their truths and be a human. So, I don't really, that's kind of just my story and my personal life, and for myself is just to just say to you guys, let people be humans, and let people struggle, and let them know that you're there for them, and they won't lose their job, hopefully, if they do come forward. So thank you for listening, and I'll pass it over to
Thank you.
Raul, I just wanted to mention
Yes.
one of the most sobering statistics that I read about law school students is 61% of entering 1Ls, the reason they went to law school to begin with was for altruistic reasons. They wanted to help others. And by the time they get out of law school, and by the time they practice, and by the time they're out, 10 or so years, they lose that vision. My other concern about this statistic is, and it goes to one that Bree was mentioning, 1Ls are more open to getting help and assistance than 3Ls. Whether it be the character and fitness process, they're afraid they won't get into the bar, they won't be able to take the bar, somebody will find out, which leads me to believe that there's something going on in the law school setting that is stymieing this growth and prohibiting students from actually getting the help they need or reaching out to another to get the help they need.
Actually, Larry Krieger and Sheldon did some major research, and it seems like this shift from intrinsic motivation to extrinsic motivation and the fear happens in first year law school, happens before second year, so there's something happening.
We'll have a few.
I don't want to go back to find out.
And along those lines, in California, we do have the Attorney Diversion and Assistance Program that helps divert a little bit what Tracy was indicating, and there's a rule pending just this month to make that program available for law students. So there's a recognition that law students need some help too. We have a few minutes for questions. Yes, sir. Sandy.
So when you, in the discipline field, when you do these deals with regard to substance abuse, voluntary suspension or whatever it is it made public that there's a mental health problem, that there is an alcohol abuse problem?
Oftentimes yes, oftentimes no, and I'll tell you what the distinction is. When attorneys raise the issue that they have a substance abuse problem or a mental health problem in mitigation, oftentimes that becomes part of the report and the recommendation of the hearing board or your court or whatever the case may be, and that becomes public. Diversion, on the other hand, or something like conditional admission, stays private. It stays confidential because it doesn't reach that level of a public complaint. The guiding principle behind that is we want to protect the attorney. We're also trying to look out for the client. And in this circumstance, because of some of the circumstances that I mentioned, no harm, no prejudice to the client, this is a first-time offense, what the offense is isn't something that's a more serious type, disciplinary and regulators feel that this is an appropriate option. We're going to give the attorney time to heal themselves, and in so doing, we're going to keep it confidential.
Thank you. Question up front?
This is for Bree. The report that y'all prepared, does it have practical suggestions, for example, for managing partners that want to engage in nurturing or wellness activities as a part of the firm culture to help change the culture of our law practice? And secondly, are the judges receptive to the fact that they're driving a lot of this pressure, and they can also be human beings to lawyers and help us with regard to changing that culture?
So in
Thank
the
you.
task force report, there's an entire section for legal employers. And one of the things where it starts in regards to the recommendations is to make the well-being of your lawyers, your staff, a priority. And do that by allocating resources and focus to that. And start by having a lawyer well-being committee. Piece of their charge would be not to just have yoga in the office or whatever, or apples in the break room, but really to look at what are some of the policies and procedures within the firm around how do we address these impairment issues? What do people do if you're worried about a colleague? Really bring it out in the open and just talk about how this firm, what are our values and our priorities, and how are we going to address these. So that's a piece of it. And again, I encourage folks to take a look at our website, lawyerwellbeing.net, to look at all of those. Yeah.
Another component of that is actually something that has grown out of Hillary Bass's working group to advance the well-being of the profession. And in coordination with the Center for Professional Responsibility, with COLAP, as well as with the Law Practice Division, on April 25th, in conjunction with the Legal Malpractice Conference, there's a national workshop that is bringing together stakeholders like you described, managing partners, risk management people, insurers, regulators, LAPs, people who HR consultants, EAPs, to start, honestly, to roll up their sleeves, to sit in round tables and start drafting model policies, suggestions that will work across the board, and to get some buy-in from the people who will be implementing these in the firms. Things that they think will actually work, can take hold, and do exactly what you said. Not just pay lip service, we have a wellness committee, but actually will change the culture from within.
We'll have a question, one last question in the back, but before I say that, in the material list that you'll receive, there's a couple of resources. One, Wellbeing Toolkit for the Legal Profession by Ann Bradford. And also, she just put out a book through the ABA Law Practice Division called Positive Professionals Creating High-Performing, Profitable Firms Through the Science of Engagement. So there's resources out there that you'll be able to go
And they're
to.
really excellent. And Ann Bradford actually was the editor-in-chief
Right.
of the task force report.
Right, excellent. And the way in the back, young lady in the back. Sorry.
Thank you to the law student who shared your story. I am a law student. I'm a third-year law student, and I'm applying to take the bar right now, and they do ask for everything but a DNA sample during your character and fitness, which has definitely changed over the years, so I've heard. So do some of these lawyer assistance programs out there go to bat for law students who may be struggling with self-help and mental health issues, substance abuse issues, who may be afraid to put that on their character and fitness for fear that they won't be able to enter the bar? I know I have a friend right now who deals with bipolar mental health disorder, and one of the questions was, do you suffer from this mental health disease? And so he's trying to decide whether he should put yes or no because he doesn't know how that's going to affect his character and fitness. So what do you say to those students, and how do these programs go to bat
Sure.
for those students?
Yeah, great question. And all of the lawyers' assistance programs across the country assist law students. All of them will provide support, referrals, and some of them provide direct services for law students such as your friend. None of them report this back to the law school or the bar admissions people.
And we
It's
have a whole
confidential.
roster of volunteer lawyers who will help that student. And I actually sometimes sit with them and help them interpret the answer. Because the questions are different state by state and province by province. And it's important that the law students get help because they're meant to be interpreted in a certain way. And I advocate complete honesty. But if you get sloppy with it, they'll end up going down a rabbit hole that's not meant to. In BC, they are meant to catch or to highlight certain things. They're not meant to as a broad scope. And I think a lot of law students see them and read them as if, oh my God, it's meant for me, and I've got to like spill my guts. I think law students would be well advised to talk to their lab and get coaching on that.
And in addition, with regard to that question, across the country, as a result of suits or other situations, that question has been changed. On many character and fitness, it's not do you have or do you suffer from, but does it impact your ability to practice? And so that's really the concern. If you have it, you can be in treatments. It may have no impact upon your ability to effectively represent clients, and so that's why that question has been changed or is being changed across the country.
So please thank me and,
Thank you.
okay, so that was a Freudian slip, right? Please join me in thanking me and the others for being here.